Hello everyone, I, Tisha from Corporate Law Journal, welcome you all to this channel. As you all know, the purpose of this initiative is to explore corporate literacy and to impart legal education in a simple and lucid manner. CLJ Judgment Series is a unique idea to keep everyone informed about the landmark rulings in corporate and commercial law. Today, we are going to discuss one recent order of National Company Law Tribunal under Insolvency and Bankruptcy Code 2016. Before starting today's session, I would request you all to please subscribe to the channel and press the bell icon for more updates on corporate and commercial laws. In this session, we will be discussing a case, Bijay Kumar Agarwal versus State Bank of India and another, where we will be covering a very pertinent question that arose before the National Company Law Tribunal on whether a financial creditor is permitted to commence proceedings under Section 7 of the Insolvency and Bankruptcy Code against the principal debtor as well as the corporate guarantor for the same set of claims. The facts of the case are: the appellant Mr. Bijay Kumar Agarwal has preferred this instant appeal and approached the appellate tribunal against the 2nd August 2019 order of NCLAT Bench, Kolkata, wherein the tribunal admitted an application under Section 7 of Insolvency and Bankruptcy Code filed by the respondents in the capacity of a financial creditor against Gene Grow Commercial Private Law Limited, who executed a deed of guarantee and supplementary deed of guarantee ensuring and guaranteeing the repayment of loan to the tune of 1,626,223,609 against the principal borrower, who is GP Infotech Private Limited, in the instant case. NCLAT Kolkata Bench adjudged that the account of principal borrower was classified as non-performing assets in 2014, and the financial creditor filed an application against the principal borrower before the Debts Recovery Tribunal, which was never objected by them, and ascertained the fact that the liability of corporate guarantor is coextensive with the principal debtor. Further, the tribunal affirmed that the financial creditor is free to sue and proceed against the principal debtor or guarantor or both as per its choice and discretion. Consequently, NCLAT admitted the application after receiving the default records from financial creditors, aforesaid facts, and on being satisfied that the default was established in repayment. Therefore, the appellants approached the appellate tribunal and filed the present appeal challenging the maintainability of application filed by the respondents under Section 7 of the Insolvency and Bankruptcy Code 2016 on the ground that two applications were filed by the respondents against the principal borrower as well as the corporate debtor for the same set of claim and default primarily committed by the principal borrower. The first issue dealt by the tribunal here is whether the financial creditor can commence proceedings against the corporate debtor and corporate guarantor for the same set of claims. The learned counsel for the appellant points out that the first respondent filed an application under Section 7 of the Insolvency and Bankruptcy Code before the NCLAT against the principal borrower GP Infotech Private Limited as well as the corporate debtor Gene Grow Commercial Private Limited for the same set of claims and default, primarily committed by the principal borrower. The learned counsel for the appellant brings into light that the NCLAT had admitted the claim based on the fact that the principal borrower had admitted the claim and had no defense. Therefore, corporate insolvency resolution process was initiated against the principal borrower and corporate guarantor. In this connection, it is the stand of the appellant that the learned adjudicating authority, while admitting the claim, had failed to appreciate that the liability of the principal borrower and the guarantor is coextensive for the purpose of recovery. Further, counsel points out that the insolvency and bankruptcy proceedings is not a recovery proceedings and relies upon Binani Industries Limited versus Bank of Baroda and another for the same. The learned counsel for the appellant cites the decision in Dr. Vishnu Kumar Agarwal versus Piramal Enterprises Limited in Company Appeal, wherein it is observed that once for the same set of claim application is filed by the financial creditor under Section 7 against the corporate debtor, a second application by the same financial creditor for the same set of claim and default cannot be admitted against the other corporate debtor. Contending in contradiction, the learned counsel for the first respondent submits that the liability of the principal debtor and guarantor is coextensive as per Section 128 of Indian Contract Act 1872 and relies upon the Supreme Court decisions in Ramkishan v. State of UP and Industrial Investment Bank of India Limited v. Bishwanath Jhunjhunwala Civil Appeal number 4613 of 2000. The Council further pleads that the appellant's argument that the coextensive liability of the principal borrower and the guarantor is only for the purpose of recovery is misconceived, and in fact, the guarantor and the corporate debtor sail in the very same boat. Since the loan was granted to the corporate debtor on the very basis of guarantee, and the proposition of choosing between the guarantor and the corporate debtor would defeat the intent of the Insolvency and Bankruptcy Code. The Learned Counsel relies on the order dated 6th September 2017, Sanjeev Shai and others versus State Bank of India and others, wherein it is reiterated that the rights of surety is coextensive with that of principal debtor. The second issue dealt by the tribunal is whether the Limitation Act is applicable to the application filed under Section 7 of the Insolvency and Bankruptcy Code by the first respondent against the appellant. The Learned Counsel for the appellant contends that the adjudicating authority had failed to take into account with the application filed under Section 7 of Insolvency and Bankruptcy Code against the corporate debtor is barred by limitation. The appellant, in reply to the application filed by the first respondent, took a plea that the application under Section 7 of the Insolvency and Bankruptcy Code filed by the respondent is not maintainable in law. Further, the corporate debtor had taken a stand that there was no debt due or payable by it as on 31st January 2018 or any other date as alleged to the financial creditor. Besides this, the corporate debtor took a stand that the application filed by the bank before the adjudicating authority was incomplete, non-compliance of the provisions of Insolvency and Bankruptcy Code and the provisions of the Banking Regulation Act 1949 and the amendments thereof and the guidelines and or circulars issued by the RBI. The Learned Counsel for the first respondent further contends that the issue of limitation was neither raised by the corporate debtor nor by the appellant before NLAT. Therefore, the appellant is stopped from taking this plea before this tribunal. The findings of the court for the first issue are: the NCLAT opined that as per Section 145 of the Indian Contract Act 1872, in every contract of guarantee, there is an implied promise by the principal debtor to indemnify the surety, and the financial debt includes debt owed to the creditor by both the principal and the guarantor. It was further held that the Section 3, Clause 11 of the Code refers to a sum that is due from any person, including a corporate debtor, and that even a mere failure of the guarantor to pay the financial creditor when the principal sum is demanded will come within the purview of the default under Section 3, Clause 12 of the Code. The NCLAT further held that the financial creditor who has a guarantee on the debt in question can commence the proceedings under Section 7 of the Code against the guarantor for failure to repay the sum borrowed by the principal borrower. Further, if a contract of guarantee itself mentions that the liability of a guarantor will be independent and separate than that of principal debtor's liability, then an application against the guarantor as per Section 7 is maintainable. However, it was clarified that the only rider to this is that a creditor is not permitted to sue the principal debtor and claim the guarantor's insolvency at the same time. In other words, a financial creditor cannot sue the principal borrower and claim the guarantor's insolvency at the same time. The NCLAT clarified that there is no fetter in the code for simultaneously projecting two applications under Section 7 of Code against the principal borrower as well as the corporate guarantors. However, the same set of claims, if an application filed by the financial creditor is admitted against one of the corporate debtors, a second application filed by the same financial creditor for the same set of claims and default is not to be admitted against the remaining corporate debtor, as the case may be. As far as the present case is concerned, this tribunal came to a consequent conclusion that the application under Section 7 of the Code filed by the first respondent against the corporate debtor Gene Grow Commercial Private Limited is maintainable in law, and the same is accordingly dismissed but without cause. The findings of the court for the second issue are: As this tribunal held that the application filed by the first respondent against the corporate debtor, Gene Commercial Private Limited, is not maintainable, it has not gone into the aspect of limitation. Further, any order passed by the adjudicating authority regarding the appointment of interim resolution professional, declaring moratorium, etc., and actions, if any, taken by the interim resolution professional against the present appellant or corporate debtor, namely Gene Commercial Private Limited, are declared illegal and are set aside. Along with this, the appellate tribunal also directed National Company Law Tribunal, Calcutta, to close the proceedings of the case and ordered that the corporate debtor, Gene Commercial Private Limited, is to be released from all the rigor of law and is permitted to function independently.